Welcome to class number 11 of our 2022 virtual HOA Condo Academy in partnership with the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe. My name is Beth Mulcahy, and I am the managing partner and senior attorney for the Mulcahy Law Firm in Phoenix, Arizona. I've enjoyed representing HOAs and condominiums for over 26 years, and my firm currently represents over 1,000 planned communities and condominium associations throughout the state of Arizona. I also currently serve on my HOA board and have for many years. Before we dive into the meat of this seminar, I'd like to start off by getting a feel for who's in our attendance today so that I can tailor the information to best serve all of you. Okay, so we're going to be launching two polls right now. The first poll is, which city do you reside? Why this is important is because we partner with the different cities throughout the valley, and they like to know who's attending from their cities. So if you wouldn't mind answering the first poll question, which is, in which city do you reside? Then the second poll question that we have is, let us know your current role with your community. Are you a board member? Are you a community manager? Are you an interested homeowner, or are you somebody else who just has an interest in our industry? And while we're getting those polling results, and if you're joining us just, on Facebook Live this morning, you can just place right in the comment section which city you live in and what your role is in the community. Okay, we're going to talk a little bit about our agenda, and then we're going to go back to our poll results this morning. Today, we're going to be talking about how to have a successful association. And I think I've seen it happen. I've also seen a lot of dysfunctional associations over the years. But what I can say is that there's no secret sauce that I can give you that gives you, the recipe for how to have a successful association. It's really a combination of a number of different things. And sometimes different things work for different associations. So we're going to try to give you some tools this morning on how your association can strive to be successful, highly functioning, and eliminate the dysfunction and negativity that might be in your association right now. In doing this, we're going to go over what are some of the best practices that I see that contribute to the success of a community association. We're also going to discuss how boards can successfully amend their association documents with our 5-step plan. Part of that discussion on amendment of CC&Rs and bylaws and rules, we're also going to be talking about 2 cases that were decided this year, one by the Arizona Supreme Court and another one by the Arizona Court of Appeals, that are giving us further direction as to how we should structure our amendments and the different responsibilities that we have as we're navigating the amendment sections and getting the votes of the members to amend these documents. We're also going to talk a little bit, very quick overview of the new HOA and condo laws that were signed into law during the 2022 Arizona legislative session. And these laws are already in effect as of September 25th. So these are already the law, but we want to just make sure that everybody's aware that there have been some changes. There's 5 new laws. We're going to spend just a little bit of time on that. And then lastly, as always, your favorite thing from what I hear from our readers and our people that are attending on Zoom and Facebook Live is the free question and answer. We'll have a free question and answer at the end of the class, and I encourage you to submit your questions via the chat box on Zoom or the comment section on Facebook Live. If you wouldn't mind, we'd appreciate it if you limit yourself to 1 question per person and try to be as specific as possible, as there's going to be no follow-up once your question has been submitted. Okay, let's take a little look at, I'm going to move over here to my second screen, my fancy technology here in this room, in terms of who's here today. Okay, I don't think this has ever happened. Oh, wait, we have 1 city that we don't have anybody here from. Okay, so we have representation today, 9% from Chandler, 3% from Glendale, 6% from Goodyear, 6% from Mesa, 12% from Peoria, 24% from Phoenix, wowza, 29% from Scottsdale, great job, Scottsdale, 9% from Surprise, and 3% from Tempe. So there's just only one particular city today that we didn't hear from. But we heard from one that we don't normally see from. You know what? I clicked out of the thing by mistake before I wrote down what the different, oops, there we go, it's back. The different people who are in attendance today. Gotta love live broadcasts. So I'm kind of surprised today. We have 74% of you are board members. That's great. 9% are managers. Welcome. Thanks for being here today. And 15% are interested homeowners and 3% are other. So this is really a great class for board members. So I'm so happy to see such a great representation today from board members and managers, and of course homeowners too, because these topics all directly impact how to have a successful association and how to effectively amend your CC&Rs. Okay, so let's start out quickly with a quick legislative update. As I said in the introduction, the legislature closed, back in June, and the new legislation, we have 5 new bills that just went into effect on September 24th, I believe. And so basically the bottom line on the legislature this year is it was one of the longest legislative sessions we've had in Arizona history. It lasted 167 days. Arizona has a legislature that is not 12 months of the year, so that is a very long legislative session for Arizona. It also was one of the most active sessions that we've seen over the past years, because we had 25 bills that were introduced in this year's legislature, the 2022 legislature, regarding association issues. And that's a really high number. And maybe in prior years, we've seen like 10 or 12. But I think it's indicative of the fact that we've had 2 back-to-back COVID years in terms of the legislative sessions, that they've been really focused on COVID issues, and they haven't had a lot of time to come back to the association issues. Ultimately, there were 5 bills out of those 25 that were introduced that the governor has signed into law. We have a great summary on these new bills if you want to have a deep dive on this topic. Basically, it's our cheat sheets that we put out on everything. We did one for the 2022 Arizona legislation, and we're going to be sharing that with you now on Zoom and Facebook Live if we haven't already. Okay, so what are the 5 bills? I want you to do a deep dive and look at the cheat sheet just because we're limited on time today, but just very briefly. The first bill is House Bill 2131. This applies only to planned communities. And the bottom line on this bill is that associations cannot ban or prohibit artificial grass in any areas where an owner owns or it's their property, and where they may already have regular turf or regular grass. The association can pass rules regarding the maintenance of it and the quality and the installation. They'll still have to go through the whole architectural process, but in planned communities, we cannot ban artificial grass anymore. Okay, House Bill 2158. This was kind of a sign of the times bill, where we were talking about community activities, informal meetings by members to discuss association issues. So I think it was kind of already pretty obvious that in a condo and a planned community that owners have, a right to use the common areas, but the legislature thought it was necessary to put into the law that owners have a right to informally meet on common areas to discuss association issues. The association can pass rules regarding those meetings, and that might be like a number of people that can be present, like they're having it at the pool, they can't exceed the maximum number of people. If the owners want to publicize the informal meeting that they're having, they can require under the law that the association notify the owners by putting it up on a bulletin board, or maybe sending out an email, or putting it on the association's website. The law specifically says that the association is required to do that. Let's see what else on this bill. I thought for sure that I would see this kind of over the past month and a half. I thought for sure I'd start to see questions on this, or maybe even owners starting to exercise their rights to do this. I have not seen that yet. And so we'll just have to, stay tuned and see what happens on that in the next year. But just know that owners do have a right to peacefully assemble is the language that the statute used. Also, kind of an interesting part of this House Bill 2158, and mind you, this bill on informally meeting, peacefully assembling, and political signs, which is the next part of it, this applies to both condominiums and planned communities. Okay, the second part of this bill says that owners can put political signs on their property for association-based issues. So like board elections, recall meetings of the board, special assessment votes. Anytime there's going to be a meeting of the members to vote on an issue, once that ballot goes out, those political signs for the association issue can be put up on the owner's property. They have to be removed within a very short time period after the meeting where this vote is going to be taken. The next bill applies to both condominiums and planned communities, and it says that first responder flags are an allowable flag under state law, and associations cannot prohibit the display of those flags on that member's property. House Bill 2275 talks about condominium termination, and it makes a more stringent requirement to terminate condominiums. Of course, that's only going to apply to condominiums. And then last but not least, Senate Bill 1168 talks about short-term rentals and gives cities and towns some additional enforcement teeth for short-term rentals that, may be violating, nuisance provisions or that might be causing problems in their cities or towns. It sets up a permitting process. It requires insurance for the short-term rental. It requires that the short-term rental owner would need to notify the neighbors the first time that they're converting it to a short-term rental, that it's becoming a short-term rental. Kind of the interesting part of this law is that it gives cities and towns the right to do this. It doesn't make it mandatory. So cities and towns are going to need to adopt an ordinance to, adopt whatever parts of these rights that the legislature is giving them that they want to adopt for their particular city or town. And we've already seen some cities. I know Chandler already has some of these restrictions in place. I know that the city of Scottsdale is discussing this right now with their city council. And many other cities and towns are now looking into passing ordinances to take advantage of what rights the legislature has given them to further regulate short-term rentals. Okay, let's dive into our first topic for today. And this is kind of a fun topic for me to teach because it talks about successful associations. Probably one of the most rewarding things that I see as an attorney that practices in this area is that I am able to witness dysfunctional associations become highly functional. And I actually have one in mind that was kind of an interesting story. Gosh, I don't know, maybe 2 or 3 years ago, I was called into a large master plan community to become their new general counsel attorney. And when I first came to the first meeting, it was very dysfunctional. And they had all kinds of legal issues. There were lawsuits that I, was not a part of at that point just because I was just being hired, but they were involved in a lot of litigation. They were fighting among themselves. The owners were unhappy. And last year, I had an opportunity at the end of the year, at the end of 2021, to go to their annual meeting. And of course, we've been working with them carefully for now a couple of years. And I have to tell you that I was sitting there and I thought to myself, this is the best annual meeting I have ever been to. And it just was so rewarding to see the transition from, a very high level of dysfunction where, they were being sued. There was some other issues regarding some mistakes that were made, and they owed some money to different, or state and federal taxes. And there were just all kinds of problems. People didn't get along. The board wasn't gelling and working together as a team. And so it was just nice to see that transition. And as I was preparing for this class today, I was kind of just doing a little check in my mind about a lot of these qualities is the quality that this particular association has. And I want you to know that, we work with over 1,000 associations throughout the state of Arizona. I would say that probably 75 to 80% of them have many of these qualities of a successful association. But there are some that are still kind of in transition and have some areas for improvement. And so these are some constructive ideas on how associations can function at a very high level. And so, kind of number one on the secrets, I'm going to go through kind of the secrets that we give about being a successful association. And we actually have a cheat sheet on this topic as well, which you can find on our website at mulcahylawfirm.com. Just go to our cheat sheet section. Okay, so what are some secrets of successful associations? Number one is outstanding communication. The associations that communicate the most, guess what? They have the fewest amount of problems. The associations that try to hide things and that try to, refuse to give members records and, have, meetings that violate the open meeting law to discuss things and vote on things outside of the membership's ear. And the associations that are just kind of being sneaky and not keeping their owners informed about what's going on in their communities, those are the ones that have problems. The associations that have good communication are the ones that, give members an opportunity. Well, first, they follow the open meeting law, right? That's kind of numero uno. They understand the importance and the value of open meetings, and they're following what the law requires them to do. So just a quick primer on the open meeting law is that all condominiums and planned communities throughout the state of Arizona must conduct open board meetings. And those open board meetings must be anytime a quorum of the board is meeting to discuss an association issue. Even if no vote is being taken, this is considered an open meeting, and the membership needs to be notified of the meeting at least 48 hours in advance of the meeting. And there are times where the board can go into what we call executive session. And the most, common topics that we go into executive session are going to be advice from your attorney, delinquencies, owners not paying assessments or fines and violations, owners not following the documents. We also go in and talk about compensation and performance of vendors frequently. Those are the most common things. Before you would ever go into an executive session, you want to follow the law and notify your owners that you are going into executive session. I would put that right on the meeting notice. We will be going into executive session immediately following the open board meeting to discuss delinquencies, violations, and pending litigation advice from our attorney, whatever the topics are that you'll be discussing that day. So part of outstanding communication is making sure that the owners know that you are not having secret meetings. And even when you're having executive session meetings, you're still providing the 48 hours notice that you're required to the membership, even though they can't be there. So kind of one first element of having outstanding communication, follow the open meeting law, know what your responsibilities are under the open meeting law, make sure that you have that agenda handy that's required under the law for any time you're having an open board meeting so that owners can follow along with what the board's going to be discussing topic by topic. Another really good idea for good communication with your owners is at the open board meeting, give members an opportunity to speak or ask questions for a set period of time. Usually this is done during the open forum. It gives owners an opportunity to vent if they're unhappy about something or to provide feedback on important topics that may pertain to your association. Another important thing we talked about is just making sure that you are sending out notice of your board meetings at least 48 hours in advance of the meeting. That can be done by conspicuous posting at the property. It can be done by putting it on a bulletin board. It can be done by sending an email out to your members. It can be done by placing it on the association's website. All of these are great tools to communicate with your owners so that they know there is a board meeting, and if they choose to attend, they have the opportunity to attend. Obviously, the pandemic's been a game changer, and that has enabled us to have more people attend board meetings and annual meetings via Zoom. So giving them that opportunity to attend virtually, I think, is important to have a successful association. Some associations, in fact, have converted entirely to having virtual meetings, and the owners are requesting that and like it, and the board likes it. Some other things that we think are really important is having a website for your association where you have a lot of information about your association at the members' fingertips. So to be successful is to, be transparent, and having the meeting minutes, having the notice of the meetings in one place, having all the forms that your association members may need for architectural changes, or a comment form for them to give feedback to the association. Having prior approved meeting minutes on your website. So if somebody wants to get up to speed as to what the association's been doing, over the past few years, they can go through and read all of the regular open board meeting minutes. Having the financials on the website are also, a great tool so that people can see real time what the financial situation is at the association. Now, mind you, a lot of these areas on the website are probably going to be password protected so that just the general public can't get in and see all this information regarding your association. Another great idea to have good communication with your owners is have town hall meetings where members can submit questions for the board, and then the board has an informal Q&A to answer questions. I especially suggest that if your association is having unrest on certain issues. If you're hearing that there's a removal petition circulating in your community, that would be a really good time to have a town hall so that you can clear up any problems or questions. If you're thinking about doing a big initiative in your community, like amending your CC&Rs or having a special assessment, or maybe a large capital improvement project, where we're going to be doing upgrades or, required maintenance at the association, having a town hall meeting to discuss how things are, the need for something, and how, the plan is for certain things is really beneficial. And, you can put that on Zoom, record it, and then even if people can't join live, they can watch it after the fact, and you can just put that Zoom recording right on your website. Another important thing that I think a lot of associations that are successful get, but some that, maybe are struggling a little bit, don't understand the importance of this. And this is having some sort of social event or events in your association to bring together the association. I know a neighborhood that I used to live in used to have a really fun Halloween party every year, and the adults and the kids really got into it. Recently, I became aware of another association that, they had a decorating contest for the homes to see who had the scariest house, best themed house for Halloween. And these all can carry into, the holidays, the upcoming holidays that we have in November and December. You could think about having like an Oktoberfest party, or a summer cookout, an Easter egg hunt, if that's something that your association wants to do. These type of things help to have the community members interact in an informal way and build community. And one of the things that I can say is, kind of different about Arizona. I grew up in Wisconsin, and we knew our neighbors. We knew all of our neighbors. And sometimes that was a good thing. Sometimes that was a bad thing. If we were doing something naughty growing up, the neighbors would tell our parents. But in Arizona, it seems more isolated. And the neighbors, probably because it's a little bit more transient, and sometimes our neighborhoods don't have full-time residents that are there all the time. So it's even more important in Arizona to plan something like a block party or a holiday party, or coffee and donuts in the park, or a yappy hour for your dogs, where members can come together and meet each other and start to build that community, because that's a pillar of having a successful association. The next thing that's really important is for the board to communicate well by responding to member inquiries. And so one of the things that I hear often, I attend a lot of board meetings, and we'll be sitting in the back, counting ballots at an annual meeting. And a very frequent comment that we hear is owners say to the board, I never got a response from the management company, or I emailed 5 times to say that the front light on the monument sign at the entrance to our community was out and no one responded, and it's still not fixed. And so it's really important, even though we're not being paid as a board member, that we are responding when owners are upset about something. And it may not directly be the board members, it may be the manager, but setting up expectations as a board and expectations for your management company, if you have one, in terms of responding to owners in a timely manner, and how important that is, because it, provides assurances to the owners that they're being heard, and they may be telling us important information that we need to hear about. If the lighting's out, or if the sprinkler's broken, or if the elevator is making a strange noise. This is all important feedback, and it's important that we respond to them and acknowledge that we appreciate them reaching out to us. Thank you for letting us know, and we'll take care of it. So responding to member inquiries in a timely fashion is very, very important. Set up expectations with the management company. As a board, tell the management company, we expect that you will respond to owners in this time frame, and then make sure that if you're hearing feedback from somebody in the community that they're not getting a timely response, that you follow up with the manager to find out what's going on and how we can improve on that going forward. Making sure that owners know how to contact the association, and maybe it's the board or maybe it's the management company. A great place to have that is right on the website. Some associations have social media accounts like Facebook or Instagram, where members can, see information about the association on that as well. Another thing that's it's like a double-edged sword, surveys. Surveys are good because it gives us feedback as to how people are feeling about the association. But they sometimes are bad in that sometimes we get negative feedback that the board maybe isn't meeting the homeowners' expectations. But I would encourage you to conduct a member survey of your community at least once every other year, just to ask them, different questions that may be pertinent for your association. A real hot topic right now is pickleball, right? And we're getting a lot of questions about building pickleball courts or converting tennis courts to pickleball. We've seen a number of associations have surveys regarding that particular topic, or other issues that may come up in your association. Okay, some other things that you can do is, if you have the need in your community, have advisory committees. Some associations have a landscaping committee. Some of them have a, welcoming committee. Some of them have a, planning the block party committee. Setting up these committees to take some of the burden off of the associations board is a great idea. Have a newsletter, and that could be done by email. If you don't have a formal newsletter, just regularly send out communications to your members regarding what's happening at your association and providing them with information regarding your association. A few other things that you could do are comment cards, where annually, if you're not doing a survey, where people can, make comments via the website. Also create, having, a welcome to the neighborhood committee is a nice thing for new neighbors that are moving in, even new renters that are moving in, maybe giving them a copy of the rules and the association documents. Oftentimes the landlord doesn't provide that information. So we want to set the tenant up for success by giving them information about the association, and, maybe like a nice loaf of bread or something thoughtful, cookies, welcoming them to the community. Okay, another really important thing. So the first thing is communication. I cannot underestimate the value of having good communication. If you do all of these things that we've talked about on communication, your owners are going to be in the loop and they're not going to be agitated and upset because they feel that they're not being informed about association issues. Okay, the next thing that's really important, the next pillar is having strong leadership. So, it's having a team where you have strong leadership is really important. And it kind of starts right at the top with the association's president and the board. So first, you have to work together as a team on your board. All the responsibilities cannot fall on one or two people. And that is what happens in many associations. So making sure that you're rounding out the responsibilities and everybody's stepping up to help in different ways. If anybody on the board is feeling like they're, managing too much, asking for help, and being able to delegate is a very important quality for board members. Otherwise, you're going to get burned out and be upset and crabby. Also, being honest, having integrity, and again, transparent with your owners. In order to lead, you have to gain the trust of your community. And the best way to get that trust is by being honest when things don't go right, and apologizing, having integrity, always doing the right thing, reaching out to your trusted advisors when you have questions that are difficult or problems in your association, or maybe the association's made a mistake. And your trusted advisors are going to be your legal counsel, your management company, your insurance company representative. Knowing when to get help is a really important skill. And last but not least, transparency, again, making sure that you're not trying to hide anything from your owners. Remember, they are entitled to see books and records of the association. If they make a records request, they are allowed to see basically everything in your community's documents. There's a few things that are exceptions they can't see. Like if you're involved in litigation, they can't see anything pertaining to the litigation. Legal opinions are the most common things, that they're not allowed to see, but basically almost everything else they are allowed to see. Okay, if you are having problems in your community with your board members not behaving properly, having the board adopt a code of conduct is a great idea. We have a sample cheat sheet that we have on our website, and we're going to be sharing it with you on this presentation too. The cheat sheet talks about the different responsibilities that a board member has. And it's a reminder to the board members to follow their fiduciary responsibilities and their duty of care, their duty to avoid conflicts of interest, and their duty of confidentiality. And it's just a great tool when board members need a reminder as to what their responsibilities are. And you only need a majority of the board to adopt the code of conduct for it to become valid and binding for your board. Okay, a couple more thoughts on how to have a successful association. You have to have commitment to the association and determination if you're serving on the board. I can tell you firsthand that I've served on and off of my board for more than 14 years now. And there have been times where I wanted to quit. No question about it. This is a thankless job, and I already have a lot of responsibilities in my life, and serving on the board is just an added one. But it's also important to me that things look nice in our community and that things are running efficiently and like a business. And so I'm committed to staying on our board because I made a commitment to do that. And I'm also determined to get things done. I am not going to get sidetracked with nonsense. I, really like to have our board have goals and to have efficient meetings. I really don't like it when we walk into a meeting and we accomplish nothing. And so I think we have to set the standard if we are serving on the board that, hey, this is a business. I'm on this because I want our community to be better. I'm not on this for a bunch of hassles and nonsense. I want the meetings to be run professionally, and I want to actually accomplish things this year. And there will be times where you have homeowners who like to have a little sideshow where they're interrupting everything. You have to have what I call board member blinders, and you have to, listen to them, of course. But at a certain point, if it becomes a broken record and there's nothing that we can do to appease that person, we just have to move forward. And you have to put blinders on and don't look in the rearview mirror and move forward. And so reaching out to your trusted advisors, if you're in one of those situations where you have a board that wants to quit, they're burned out, or you have an owner or owners who are driving the board nuts or driving the management company nuts, that's a really good time to reach out to our firm. We, see situations like that, unfortunately, frequently. And typically we'll come in and have a boot camp with the board and try to turn things around, try to get things moving in the right direction. So really important, criteria for serving on the board and for your community is being committed to your community and being determined to overcome obstacles and get things done when you're serving on the board. I think those are probably, the most important things that, I feel are necessary to have a successful community. Of course, there are other things which are kind of more legal, but, making sure that your association is financially sound, and having a reserve study done for your community and making sure that that reserve study is updated about every 5 years, adequately funding your reserves, filing your state and federal taxes, working effectively with your management company, and being able to delegate things to them and having the management company get those things done, having your management company oversee other vendors in your community. There's so many responsibilities of, serving on a board. It really is a lot of different hats. You got to be a good communicator. You have to be a great leader. You have to oversee all of your vendors. And you have to make sure that the common areas are being maintained. You have to make sure that you have adequate insurance. You want to be thinking forward about the future, 5-year plan, 10-year plan. It's not an easy job. So, but kind of the underlying things that you really need to keep in mind is if you want to have a hassle-free time on your board, you really do need to have that good communication. And you need to have strong leadership with your board working together as a team to make things happen and to handle difficult problems. Okay, so I hope that was a good overview on how to be a successful association. I hate to ever leave anything out, so we only have limited time here today, but just kind of in closing, make sure you're looking at our cheat sheets and our videos on our website. We have so many free resources for board members, managers, and owners on our website at mulcahylawfirm.com. Really, any topic that your association may be having difficulty with, I pretty much guarantee that there's going to be a blog article, a short video, or a cheat sheet to help you navigate and get, just the baseline information that you may need to help you. And the great thing about it is it's all available 24/7. So if you're up late worrying about a problem, just go to our website, go into the search engine and try to find something that's the topic that you need more information on. Okay, let's switch gears and talk a little bit about how to amend association documents. This really has become a very popular topic since the pandemic. I've been through a number of different cycles now in Arizona with the economy, and it just seems like it's just kind of, there's up and down variables that happen over the years, and I've probably seen 3 or 4 downturns in the economy in my career now. And what we find is when there's a boom, typically there are a large number of associations that are amending their association documents. And then when there's a bust, when the economy starts to tank, then we see a large number of collections and the owners not paying their assessments, et cetera. And then the association has less funding to do amendments. So it's kind of like it is cyclical when we see associations amending their documents. Just kind of a first line of defense thing I want to mention is that associations really should be amending their corporate documents. So that would be like your CC&Rs or your declaration, your bylaws and your rules, potentially your architectural guidelines. You should be thinking about amending them or updating them at least once a decade. Now, I'm pretty confident that there are a number of you on this call today who have never amended your documents for your association, or maybe you haven't amended them in the last decade. Why is it important to amend your documents once every 10 years? Well, first, it's important to delete or modify any restrictions that are outdated or that aren't in compliance with local, federal, state laws. And you may have information in your CC&Rs or your bylaws that directly contradicts what state law says. Or you may have information in your CC&Rs that is not consistent with how things are really operating in your association. So maybe you have your streets are clogged with cars at night, and maybe your CC&Rs say no parking overnight on the streets. And so it's good to evaluate these things every decade and see if we have things in our documents that need to be changed to comply with Arizona law. And also to delete or modify provisions that are not consistent with how things are operating in your association. Lots of times associations still have all that old developer language in the documents, and that really needs to be removed. Often we see conflicts within the corporate documents for your own association. Like we'll see the bylaws will say that you have to have 5 directors, and then the CC&R say you have to have 3 directors. And so it's a maximum of 3 directors. So there's conflicts within your documents, and it's very confusing for the board as they're trying to navigate that. And so those are the reasons why you want to amend your documents once every 10 years. Probably the most overreaching reason in my mind is that state law is changing every year, and your documents probably have language in there that violates state law and federal law. And it's really important that you update that so that you don't have miscommunications with your owners and so that you're following the law. Okay, so let's talk about how do we amend the documents. We have a great cheat sheet that we have given out, so many of these, probably, I don't even know how many, probably 100,000 in 25 years. And this cheat sheet is called Amending Association Documents and Implementing Rental Restrictions. And this cheat sheet has been fine-tuned for over 20 years to give you the best possible formula to amend your documents in your association successfully. So I would encourage you to take the deep dive and look at that cheat sheet. It has some great information on it, and I'm going to give you a quick verbal overview of our secret recipe to our 5-step plan for amending association documents. So we break it down into 5 different distinct steps. And so the first step is somewhat easy, but I've got to have a little caveat on it. You got to take your time on this step. So the first step is determine what is required to amend the documents. So the board of directors should look at the actual documents, and they should talk with their legal counsel. The amendment section in the CC&Rs and the bylaws are the sections that you're going to be looking at. Most of these documents, the CC&Rs and the bylaws, are going to require approval of the membership to amend the documents. There are some very rare cases where the board can amend the bylaws without a vote of the membership. But if you are going to do that as a board and your documents or bylaws allow you to amend the bylaws without a vote of the membership, you would, under state law, need to do a notice to your members that you're planning to vote on this at an upcoming board meeting. And you would want to put in the notice of meeting or the agenda of the meeting that the owners get the actual changes you propose to make in the bylaws, so that owners have notice that you're going to be making this change to the bylaws. But that's kind of a rare instance where the board can amend the bylaws. more likely than not, like 95% of the time, you're going to need a homeowner vote to amend your documents. And you're going to have to look at your documents specifically to see what percentage of homeowners are required to amend the documents. Every association has different documents. So unfortunately, I can't give you like a bright line rule that it's always X percentage because every association is different. And so, very important that you look at the specific language of the documents to determine what specifically you need to amend the documents. Why it's important to have your attorney involved is because there are a whole bunch of laws and case law that pertain to amending association documents. And you want to make sure that you know the exact correct percentage for your association. Because let's say you're a condominium and you go to your CC&Rs for your condominium and it says you only need 51% approval to amend your CC&Rs. Well, there's a state law in the Condominium Act, Arizona Revised Statutes 33-1227A, that says that you cannot amend your CC&Rs if you're a condominium unless you have 67% of the votes within the condo association. So that's a minimum, that you would have to meet. So even though your CC&Rs may say 51% for a condo, there's actually a state law that says no, it has to be 67% minimum of the votes to amend the documents in the CC&Rs in a condominium. So just kind of real important thing for step one. Okay, the board should go and look at the amendment sections themselves first to get a general idea of, okay, this is what we may need. Then I recommend that you talk to your legal counsel and verify that, okay, this is the percentage that we need, and this is the procedure that we need to follow to amend our CC&Rs or amend our bylaws. Typically, the rules are promulgated by the board at a board meeting. So you typically don't need a vote of the membership for the rules. Some associations, in very rare instances, do need the owners to pass the amendments to the rules, but more likely than not, the board passes the amendments to the rules. So step one, what is required to amend the documents? Check the documents, verify with your association's attorney. Step number two, this is the longest step in the entire process. And basically, what happens in this step is that associations are going to come up with the changes that they want to make to the documents. And so they review the documents and they make changes and draft the proposed changes. Sometimes the board does this initially. Sometimes your legal counsel does this first. The best way to do it, in my opinion, is to put the documents, so the CC&Rs and the bylaws, into a Word document. So copy it word for word into a Word document. And then do track changes. And as you make the changes in the computer program, it's redlining any deletions and underlining any additions so that we can keep track of what's being changed. And what I really prefer as legal counsel that's worked with associations for over 25 years is I prefer that the board just lets me do this first draft myself, because I know exactly what I'm looking for when I'm doing the changes to the CC&Rs and the bylaws. And I like to get the first, crack at it because it's just so much easier and it's going to cost you so much less if you let me do it first. If you do it the other way, where the board comes in and they make a whole bunch of changes to the documents, sometimes I have to spend time undoing the changes that they've made. And that's just so unnecessary. It's smarter to give it to the lawyer, have them make their changes. And then we give the document to the board or the committee, whoever's handling the amendments. And then they start making their comments and changes. And typically when we do it that way, it's easier for the board, it costs less in the long run, and it's a much cleaner looking document in terms of tracking the changes. And so that's step two. So review the documents for changes and then draft the proposed changes. Step three, this is the step that the boards always want to skip. Do we really have to do this step? Yes, you do. And here's why. Step 3 is educating and soliciting support of the community of the proposed changes. Now, we said in step 1 that you are going to determine what the percentage is that you need to amend the documents. So for 95% of the amendments that you're going to be doing, you're going to need a high percentage of owners to approve the changes, whether it's 67%, 75%, 90%. In a planned community, it could be as low as 51%, but that's a lot of people. And so if you're going to be sending this out to vote for the members to vote on the changes, you don't want the first time for them to see it to be the time that they've got the ballot and they're voting on it. Because if they're not happy about it, they'll just vote no, and you'll have wasted a lot of time, effort, and money coming up with the changes. So what you want to do in step 3 is you want to give them a preview and ask for their feedback. So in step 3, we send out the proposed document that we're thinking about, sending to the membership for a vote. And we ask for their opinion on it. And we give them a way to comment on it, whether it's by email or sending in a comment card. And, so by doing this, we're getting important market research, right, as to how people feel about the amendment. And we're also getting them involved in the process. And we're telling them that now is your time to comment. If you don't like something, let us know. And what we find is maybe 10%, 5 to 10% of the community actually takes the time to respond. But the information that we get from the owners that actually do respond is really helpful in helping us determine how we want to structure what we send out to the members. And so then we move into step 4. So now we've sent out the proposed changes to the members. They've given us their feedback back. Now we're analyzing and strategizing about the feedback in step 4. So step 4 is we're developing a plan and a reasonable time frame for obtaining approval of the proposed amendments. So in step 4, we take the feedback that we got from the members, and the board and the association's attorney will have a short meeting, and we'll talk about, okay, well, we got a lot of feedback on the rental restriction, and owners aren't happy about that. And, is this something that we want to leave out? Is it something that we want to vote on separately? So we'd have one vote on, all the changes to the CC&Rs, and then the controversial vote would be a separate vote on the same ballot. And so there's lots of different strategy ways to handle this. And I'm a very, a good person to strategize with in step 4, because I've been through this a lot of times with many associations. And my goal is to get you across the finish line. So we come up with how we're going to structure the amendments. We may throw things out. We may separate them and vote on them on the side. We may reword them based upon the feedback. Then we come up with our game plan for the ballot. And we come up with our game plan for, are we going to have a meeting to discuss the votes? Are we going to have a bunch of coffee and donut mornings where we, try to get people to vote by coming to those? We have a whole plan. Are we going to have a telephone tree? Are we going to have block captains that are going around getting votes? And we come up with our timeline for the voting and how long we're going to leave this open, and then what our plan is going to be to monitor the votes as they come in, and to continue to follow up with people who haven't voted, et cetera. So that's kind of our plan, at step 4. So finalize the language that we're going to put in the amendments, finalize the ballot language, and then come up with our timeline for how we're going to send out the ballot, how long we're going to leave the ballot out there to vote, and how we are going to actually get people to return their ballots to vote. Okay, then the last step, assuming that we're successful in step 4, and if you've come this far, having that plan is really important, following the plan. Now we're at step 5, which is success, right? It's passed. Really important for everybody to know, once you get the number of votes that you need, the percentage, you only have 30 days to record that amendment to your documents. So it's very important that, you are cognizant of that and counting those ballots. We do an Excel spreadsheet in our office. We typically help count the ballots for most of the associations that we do the amendments. We work with the association on the amendments with. And so we're monitoring frequently throughout the process where we are in the percentage of votes that we need. Once you get that percentage, you have 30 days to record that amendment. And it's important that it's done. It's mandatory. So also, when you get to the stage that you're going to be recording the amendment with the recorder's office for whatever county you live in, you want to be really careful that you do it the right way. There have been 2 cases decided in Arizona, one in the Court of Appeals, one in the Supreme Court of Arizona, that have talked about, what's valid and what's not valid when you're doing amendments to CC&Rs. So the case that was decided last week by the Arizona Court of Appeals is a case called MOUNTZ versus Mountain Gate. And basically in this association, I'm just going to give you the bottom line on it. Basically, the way that the board recorded their amendment to the CC&Rs was ineffective, and they didn't do it right based upon the language of the actual amendment section in the CC&Rs. And so, basically what the court did is they struck down the amendments in that case because they said that the amendment was invalid based upon an ineffective amendment process. And they, said that the association was prohibited from enforcing the new set of CC&Rs. And so, the bottom line is that they needed to have the amendment that they recorded with the CC&Rs. They needed to have, all the owners sign off on the amendment, unfortunately. And, basically what they did is the association only had the association's vice president certify that the amendment was adopted by the lot owners that they were required to, but the actual amendment language in their CC&Rs, their specific CC&Rs said that the amendment had to be executed by, the percentage of owners. And that means that they would have had to sign that amendment, the actual amendment paper work before they recorded it. So again, attention to detail on these amendments. This is not something the board should be doing without legal counsel, and you need to carefully analyze every step of the process to make sure we're doing it right. The other thing that I want to mention is there was another case that was decided by the Supreme Court of Arizona in March of 2022. This is the Kalway versus Calabria Ranch case. And basically, this is kind of a problematic case. I'm not going to lie to you. This is a problem. I don't agree with the decision that was rendered by the court in this case. But I want to just make a couple comments on it. So the bottom line is that this case allows or gave courts the right to blue pencil any amendments to CC&Rs, and they can eliminate things that they feel are grammatically severable or are unreasonable. And they also said that amendments to the CC&Rs have to be, foreseeable, and you have to give sufficient notice that the section can be amended in the future. And so the bottom line on this case is, just in my opinion and based upon my 25 years of experience, is yes, the Kalway case is problematic because it's giving the court a lot of authority to strike down the amendments. But don't overcorrect based on this case, okay? The Calabria Ranch case had very unusual facts. They had, it basically only had 5 lots in the association, and, a couple of the owners teamed up on one of the other owners, didn't tell them about an amendment, and then passed something that harmed that owner's, property values. So, obviously that was not, the right way for that particular association to handle that. And it resulted in the court really coming down and cracking down on, the amendment process in that case. So what our firm is telling clients is, we are still doing CC&R amendments, even despite the Kalway case. We are being strategic in how we're handling the amendments. We are making sure that we have good language in the amendments so that, it can't be challenged in court, and we're limiting our liability through the language. Okay, so just important to know about those two cases. The courts have kind of stepped in and started regulating some of these amendments. They're being done by associations. Another reason why it's important to have your legal counsel look at the amendments throughout the entire 5-step process that you follow to make sure that you're doing everything right. So step 5, you've passed your amendment now. Your homeowners have voted for it. You've recorded it after 30 days of getting the last vote. And now the last step is just to notify your owners that the amendment has been passed, and to make sure that your management company is giving new owners the correct set of CC&Rs or bylaws for your association, and then move forward and enforce the new set of CC&Rs. A couple of important practice pointers. Remember, CC&Rs are recorded with the recorder's office in the county that you live in. So any amendments that you have are recorded. Bylaw amendments are just placed with the association's records. They are not recorded. And they obviously, you want to give a copy of any amendments to the owners, and then any future owners through the disclosure process should get a copy of the correct documents. Okay, so I think, we've covered basically everything that we need to cover today. We've talked about successful associations. We've talked about our 5-step plan to amend your association documents, and that really needs to be done every 10 years. We kind of talked about the 2 new cases that the Court of Appeals has decided this year, one of the Court of Appeals case, one Supreme Court of Arizona case. And we've talked about the new legislation. So the 5 new laws that went into effect in September. So we covered a lot of material today in an hour and 3 minutes. So a couple things to think about. We're entering, holiday alley, so to speak. So I cannot believe that it's Thanksgiving next week. Happy Thanksgiving, everybody. Hope you have a wonderful time with your family and friends. And of course, I'm so thankful to the different cities that we work with to put on this virtual neighborhood services HOA Academy. Thanks for partnering with us this year. We really enjoy the opportunity to provide these classes, free classes for residents of many different cities in the Valley. A few things to think about as we start to, close out 2022. Our last neighborhood services presentation for 2022 is going to be on Friday, December 2nd at 9:00 a.m. So we're having a little change up on the date. Normally we meet the 3rd Tuesday of every month, and we meet at 11 a.m. But in December, due to the holiday, we are going to have our neighborhood services virtual HOA Condo Academy, our December class, the first Friday of the month. And this class is going to be only question and answers. So bring your questions, big and small. We will answer them all. So we really encourage you to participate by submitting questions. We'll answer every legal question pertaining to associations on Friday, December 2nd, starting at 9 a.m. And we'll keep going until we finish. And so it's for those of you who may be familiar, we're kind of combining our neighborhood services virtual HOA Condo Academy for the month of December with our first Friday virtual free call-in. So if you want more information on that, you can go to our website at mulcahylawfirm.com and click on our upcoming seminars or upcoming classes. And you can submit questions right there. And you can continue to submit questions right up to December 2nd at 8:45 a.m. So as you think of questions throughout the month, submit them there. And if you can't join us live at that time, as always, we have you can go to our Facebook Live, our Facebook page for our firm, and you can see the videos there. And we also post the neighborhood services classes always on our website. Speaking of that, our videos for our classes that we've been teaching over the past 2 years have now passed 60,000 views. So those are a great resource for everybody as you have questions on different topics. And if you want to go back and re-listen to something that I've said, they're all posted on our website, so you can look at them anytime. Okay, one final parting point before we sign off for today. We talked today about amending CC&Rs, and I just wanted to offer between now and December 31st, our firm is offering a free review, 15-minute free review of your CC&Rs and or bylaws for your association. So if you're thinking about amending your CC&Rs, we will spend 15 minutes for free reviewing them and give you feedback as to how to amend them and some things that we think you might need to change. So that's kind of a good little free thing that we're offering to our clients and to anybody who may want to become a potential client of our firm. All you need to do is email me with your request and your CC&Rs and your bylaws as an attachment to the email, and then give us about 2 to 3 weeks to do that, and then we'll get it back to you so that you can take a look at that and maybe put that on your agenda for 2023. So thanks again, everybody, for being here today. Appreciate you being here very much, and I hope all of you have a very happy Thanksgiving and safe Thanksgiving. And I will look forward to seeing you again on Friday, December 2nd at 9:00 a.m. for our last class of 2022. Thanks, everybody. Take care. Bye.